Alright people, welcome to Jumbo IS and welcome to Polity lecture number 2 in this lecture series called Prelims Powerplay 2026. As you all know, that through this lecture series, we revise everything for UPSC Prelims. All your revision for UPSC Prelims would be taken care of if you follow this lecture series diligently and properly. And you won't have to spend that much time of your day also if you are following it properly. Now, through this lecture series, we'll not only cover all the current affairs relevant for prelims, subject-wise, we'll also cover the associated static topics as well, because those static topics which have some connection with current affairs have a higher probability of featuring in your prelims examination. Therefore, we will revise everything in a systematic manner. But for this, you have to follow these 4 steps. Step number 1, watch the lecture regularly. Every day at 9 p.m., the lecture would drop. You have to watch it regularly, be consistent with it, don't keep lectures pending. Then step number 2, along with the lecture, you'll also be given some notes. There would be some extra information in your notes as well. Memorize those notes. Then step number 3, we'll be enrolling you in our WhatsApp groups, which are specifically created to address all your doubts. Those WhatsApp groups are active 24/7. So as soon as a doubt occurs to you, you just have to ask it and we will take care of it. Okay, so this is step number 3. And last, step number 4, well, along with this lecture series, you'll also be getting access to our test series, which will contain an exhaustive list of tests. Be regular with the tests. Don't miss out on all the tests, because the thing is that generally there is a tendency that people postpone their tests because they think that they are not adequately prepared. Don't do that. As soon as the test drops, give the test, because tests are crucial. Test series is crucial for securing a rank in UPSC as well as clearing your prelims along with that. So that is why follow these 4 steps. Now, as far as step number 1 is concerned, you don't have to worry about it. The lectures would be dropping free of cost on YouTube. But for notes, for WhatsApp groups, and for the test series, you would have to register on our app or on our website. The link to our app and website are given in the comment section below. Just click on the link and fulfill the registration process, and we will enroll you in our WhatsApp groups and will give you access to our test series. All right then. That would be all as far as the introduction is concerned. Let's straight away jump into Polity lecture number 2. And our today's topic of discussion is right to equality. Now, in the year of 2025, there were so many Supreme Court judgments and a lot of current affairs that basically had some connection with right to equality. Now, right to equality is a fundamental right in our constitution, and it basically is covered by Article 14, 15, 16, 17, 18. These are the 5 articles. Now, we will cover these 5 articles, some static information related to that, and all the current affairs related to each and every article. Current affairs related to Article 14, 15, 16, 17, 18. Everything would be covered in this one lecture. All right. So let's quickly dive into the lecture. Let's quickly begin. So Polity lecture number 2, right to equality. And this right to equality is basically covered from Article 14 to Article 18. These articles are part of Part 3 of the Constitution, which covers fundamental rights. Yes, we all know about this. Now, let's take a brief overview of all these articles, 14 to 18. Okay, let me change the color of the pen. Yeah. So, articles over here. So, Article 14 deals with equality before law and equal protection of law. Article 15, well, it basically prohibits state from discriminating against people on the basis of religion, race, caste, sex, place of birth. Then Article 16 offers equality of opportunity in public employment. Any government jobs, there would be no discrimination. Article 17 abolishes untouchability, and Article 18 abolishes titles. During colonial times, you all know this, that there were these hereditary titles like Zamindar, Jagirdar, right? Raja, Rai. All these titles would be abolished. So these are basically a brief overview of all these 5 articles. So 14 deals with overall equality. Okay, there shall be right to equality. And all the subsequent articles are more specific. So 14 is more broad. It encompasses everything in India. 15, 16, 17, 18 are specific. Like 15 is for no discrimination by state, 16 is for public employment, 17 is for caste discrimination, and 18 is for these hereditary titles. Clear? So these are basically the 5 articles that cover everything with respect to right to equality in India. Now let's discuss each and every article and the subsequent landmark judgments with respect to them, and the judgments that were passed in the year 2025 with respect to them. Let's cover all these things. So we will begin with Article 14. Okay. So yeah. So Article 14, the text, let's read what is actually written in the Constitution. So Article 14 says, state shall not deny equality before law and equal protection of laws within India. So focus on this statement. Okay. State shall not deny, basically state will provide right to equality. But there are two kinds of right to equality. One is equality before law. Okay. Now this concept of equality before law was of British origin, kind of British origin, comes from the British concept of rule of law. Okay. And it is basically negative. It says that the law shall not discriminate against anyone. Okay. Because before rule of law, what used to happen was, for a crime there was different set of punishments for landed elites and different set of punishments for lower class people. Okay, that was not equality before law. That is why in the courts there is this portrait or there is this sculpture of Lady Justice, and Lady Justice is blindfolded, which means that in the eyes of law we don't see caste, creed, class, nothing. There will be no hierarchy. Every person shall be equal in the eyes of law. Okay, there shall be no discrimination. If there is a law that there is capital punishment for murder, then everyone is subject to it. Okay, this is basically a British concept. Then equal protection of laws is basically a American concept. Okay, now what does equal protection of law says? Equal protection of laws, to put it simply, says that equals to be treated equally, unequals to be treated unequally. Basically what it says is that there are certain disadvantaged sections of society. Okay, we need to bring them equal in social terms, in economic terms. Therefore, if you are giving them any special concession so that you can bring them at par with forward classes, okay, if you are making any special concession for them, if state is discriminating in favor of them so that they can bring them at par with the forward classes, then that is permissible. This is equal protection of laws. It is of American origin. So reservation basically comes under this category. That yes, state shall not discriminate, equality before law, but for certain disadvantaged sections, to bring them at par with other classes, we will make special concessions for them. Okay, so this is there. Clear? Now, the thing is, sometimes the states make these special concessions. Okay, and these special concessions are challenged in the courts. For example, reservations were challenged in Supreme Court and High Court. Now, they are challenged on the basis of that they are violating right to equality. But the state says that we are fulfilling this promise of equal protection of laws. So who will decide whether state is actually fulfilling equal protection of laws or not? Okay. So all these forward actions, affirmative actions as we call them, well, they are judged by the Supreme Court or the High Courts. And they apply two tests for it. Okay. So if state is making some special concession for certain community, well, the courts will first apply this test called intelligible differentia. Okay. What is intelligible differentia? That you have created this another category of people, this category of people for which you are giving special concessions. This special category of categorization of people should be intelligible. You can't say that people who are left-handed are one category, people who are right-handed are one category, and we are favoring the right-handed people. This categorization, left-handed, right-handed, is not intelligent. But if you say that we are classifying people based on their gender, male and female, or the third gender, if this is a categorization, well, it is visible. Okay, left-handed, right-handed is a stupid categorization. But men, women, upper caste, lower caste, upper class, lower class, these categorizations are visible. So first, the categorization done by state should be visible. It should be intelligible. So this is intelligible differentia. Then the courts will apply second test, which is rational nexus. Okay, what is rational nexus? When the government will make a special law for disadvantaged sections, okay, the courts will see whether these special concessions given to lower disadvantaged people, will bring them at par with forward classes. So whenever the government makes a law or takes any action, the government mentions that the purpose of giving these special concessions is to improve their socio-economic standard. So courts will check whether these concessions are improving their socio-economic standards or not. If these concessions are vague and they won't have any impact on the improvement of their lives, the courts will strike down those actions. Okay, this is rational nexus. Rational interconnection between the concessions being given by the state and the objective of giving these concessions. These tests are applied. Okay, based on these two tests, reservations were justified by the courts, permitted by the courts. Okay, so this is very important. Plus, in a very famous landmark 1974 Royappa case, court said that any arbitrary action taken by the government, which is arbitrary, vague, also violates right to equality. Right to equality says that no arbitrary action shall be taken by the state. So any action taken by the state will be judged by the courts based on their arbitrariness. If they're arbitrary, the courts will strike them down based on Article 14. And this doctrine of arbitrariness was given in E.P. Royappa case in 1974. It said equality is antithesis, that means contradictory to arbitrariness. Okay. Now, this statement, state shall not deny equality before law and equal protection of laws, does not apply on president and governor. Certain immunities are given to president and governors, and you can't challenge those immunities based on right to equality. These would be immune. Plus, foreign sovereigns like president of some other country, diplomat of some other country, they are also immune to right to equality. You can't say that the government is giving some special facilities to French diplomats. This is violation of right to equality. You can't say that because this is international obligation. You understand? So remember these exceptions. Now, within Article 14, there are some landmark cases which are given in a table form in your notes. What are those landmark cases? Okay, number 1, 1952 Anwar Ali Sarkar case, which gave basically intelligible differentia doctrine, that you can give special concessions, but your categorization of people should be intelligent. Okay, then Ramakrishna Dalmia in 1958, this gave the two tests. Okay, rational nexus test was given in this case. Then Royappa, arbitrariness was given, new doctrine. In Menka Gandhi, the court said that there is connection between Article 14, Article 19, freedom of speech and expression, and Article 21, right to life. These are pretty much interconnected. We'll talk about this interconnection when we'll cover 19 and 21. Then Ajay Hasya, arbitrariness again. Then Indira Sahni case, the landmark case on reservations. This gave the 50% ceiling rule, that no reservation can exceed 50%. Okay, 50% ceiling. That give all sorts of reservations, but it shouldn't exceed 50%. Then Shahbano case, the triple talaq case. Okay, basically divorce laws are different for women of other religions, but they are different for women of Muslim religion. So this is a violation of right to equality, because a Muslim woman cannot seek same protections as a Hindu or a Sikh or a Jain or a Christian woman can. Okay, so based on this doctrine, based on right to equality, court ruled in favor of Shahbano. Okay, so this is the thing. Now, in 2025 also, there were certain judgments which are related to Article 14. Okay, Surendra Kohli versus State of UP. Basically, what happened was, this man, Surendra Kohli, was, he was accused of certain very bad killings, murder. Okay, these were called Nithari killings. Now, the police basically presented evidence in an arbitrary manner. Okay, so there was evidence presentation inconsistency in different cases. So court said that this is arbitrary, this is violation of right to equality, so he was acquitted. It was a big controversial news, but he was acquitted. Then Allahabad High Court judge transfer case. Okay, denial of procedural safeguards. So some people were given some safeguards, some people weren't in case of transfer of judges. So this was struck down. Then there were other cases also, which are given in your notes in a similar table form. Do go through this, because this is part of your current affairs. because in 2025, these landmark judgments took place with respect to right to equality. All right. Now, in your notes, there are some key definitions also. For example, intelligible differentia definition is given, rational nexus, reasonable classification. Okay, intelligible differentia is reasonable classification. Then arbitrariness definition is given. Then there is this thing called formal equality and substantive equality. These definitions are also given, okay, with examples. So do go through this as well. All right. And now let's move on to next article, and that is Article 15. Now, Article 15 basically deals with, well, state discrimination. The text reads, state shall not discriminate against any citizen on grounds only. This only word is important. That state shall not favor or discriminate against any person only based on their religion, race, caste, sex, place of birth, or any of them. Okay. So these identities will not matter in any state action. This is clause 1 of Article 15. Then you all know that this article puts a prohibition on state. But there are many private people who also practice untouchability. So there are some public parks where these people, actual private individuals, prohibit entry of lower caste people. This was a situation in our country at one point of time. Yes, there were certain, lower caste people were prohibited from taking water from wells, tanks, entering hotels, restaurants, all these things were there. Now, those people can say that these wells, tanks, hotels, restaurants are private, so they are not covered under Article 15. So to specify it, clause 2 was added. It said that no citizen shall, on grounds of religion, race, caste, sex, place of birth, be subject to any disability, liability, restriction, or condition with regard to public places. These private spaces were also categorized as public places where general public comes. Okay, hotels, restaurants, cinema halls, all these things. So this applies restrictions on private individuals. Then clause 3 says that nothing in this article shall prevent the state from making any special provision for women and children. Okay, so you might say that religion, race, caste, sex, based on sex, state cannot discriminate against anyone. But state makes certain special concessions for women. You might say this is a violation of Article 15, Clause 1. So Clause 3 clearly specifies that any special concession for women and children shall not be challenged based on this line. Okay? And then through subsequent amendments, other clauses were also added. Now, what were those other clauses? So clause 1, 2, 3, known to you. Okay. Clause 4 is providing reservation to SC, ST, OBC. Okay. Now, for this, there was this famous case, Champakam Dorai Rajan case. And to allow for this, well, first Constitutional Amendment Act, the very first Constitutional Amendment Act was enacted, which inserted clause 4, which allowed for, well, SC, ST, OBC reservation. Then for clause 5, 93 Amendment, reservation in private educational institutions for SC, ST, OBCs, okay, for private, not public. Clause 3, which was added, clause 6, which was added through 103rd Constitutional Amendment Act, which allows for EWS, 10% EWS reservation. So these are the amendments and these are the clauses that were inserted. Okay. Now, certain landmark cases with respect to Article 15. Okay. Landmark cases. Number 1, Champakam Dorai Rajan case, which Supreme Court said that SC, ST reservation is allowed, and that is why first Constitutional Amendment Act was passed. Okay. Then MR Balaji case, which gave 50% ceiling guideline, reasonable reservation doctrine was given. Then Ashok Kumar Thakur case, clause 5 was held valid, OBC creamy layer concept. Then Nalsa, reservation, also not reservation, but special concession for transgender people. Okay, this was in this judgment. Clear? Now, as far as certain 2025 current affairs cases are concerned, these are given in your notes. So all the important cases that were related to Article 15, that were, or judgments that were enacted or given in the year 2025, which is part of your current affairs, right? These are given in your notes in a similar table form. So don't worry, just go through it once. Okay. and we shall quickly shift our focus to Article 16, which specifically deals with public employment, government employment. Basically, the idea is to give a level playing field, equality of opportunity to everyone, irrespective of their identity, ascriptive identity, in matters of public employment. Okay. So there shall be no discrimination. No citizen can be discriminated against in employment due to religion, race, caste, sex, descent, that you're of Indian origin or anything, place of birth, residence. But in certain areas, like for example in Nagaland, Naga people want that certain government jobs should be reserved for people who are living in Nagaland. Okay, there are certain regional sensitivities also. So this article says, although this article says that you can't discriminate based on residence, but it allows Parliament, remember, Parliament, to basically enact a law which will give certain regions to basically put this qualification in public employment that you should produce your domicile. So in Telangana, certain jobs are reserved for domiciled people of Telangana, okay, for Nagaland. So residence can be used as a qualification for your public employment in certain category of jobs. But the condition is Article 16 is very clear that you can't discriminate based on residence and all. But if Parliament enacts a law, so remember, Telangana Legislative Assembly cannot enact this law. Parliament has the authority to enact this law to give residence as a qualification criteria in certain regions. So the authority is with Parliament and this is specified, and that is why we have for certain jobs domicile as a qualification criteria. Clear? Now Article 16 also allows for reservation, SC, STs, EWS, everything is there through subsequent amendments. It is given in your notes. Okay, this part is very important. Now there are certain religious institutions which are managed by government. So any jobs in those institutions would be categorized as public employment. Now let's suppose we are talking about Muslim institutions. Okay, now those Muslim institutions should be managed by Muslims only. As per logic, those Muslim religious institutions, even if it is managed by state, should be, I mean, the hiring should be that of Muslims. Yes, but someone might challenge the government and say that, well, no, you have clearly told us that there will be no discrimination in public employment with respect to religion. So how can you reserve these posts for Muslims only? So this article has made it clear that laws can allow persons of a particular religion to manage religious or denominational institutions. So for certain government management of religious institutions, government by law can specify that only members of those religions can apply for jobs over here. This won't be categorized as discrimination. It's sensible also, right? Now, this is a table much like your Article 15 table, okay? So certain articles were added later through amendments. So as you can see, so Article 1, 2, 3, which requires residence. Article 4, basically reservation for backward classes if unrepresented. This is given. Post Indira Sani case, 50% ceiling was done. Article 4A, which allowed for reservation even in promotions for SC, ST. Article 4B, carry forward rule for unfilled vacancies. Carry forward that if 100 seats were reserved, there were 100 seats, 50 were reserved for general, 50 were reserved for reserved categories. Okay. Now, in reserved categories, only 20 filled. 20 seats got filled, 30 were left. So these 30 seats would be put on advertisement in next year. So next year, well, 100 seats would be advertised, but these 30 previous year seats would also be advertised, saying that there are total 130 seats, 50 would be reserved for general and 80 would be reserved for reserved categories, and nobody can say that you are breaching 50% rule because these are previous year seats. So carry forward rule was also there. The reservation for Anglo-Indians, that expired because we don't recognize them. Now these are some landmark cases. Devadasan case, which gave 50% rule in public employment. Indira Sani case for OBC. Creamy layer definition was also given over here. M. Nagaraj case. Well, it says that you have to prove the backwardness of a particular community to make them eligible for OBC reservation. Then Jarnail Singh case. Creamy layer concept won't be applied to SC, STs. Creamy layer concept only applies to OBCs. Okay. And now let's move on to next news item, article, and that is Article 17, which explicitly prohibits untouchability. Okay. So untouchability is abolished and its practice in any form is forbidden. The enforcement of any disability arising out of untouchability shall be an offence punishable in accordance with law. So remember this, Article 17 prohibits untouchability. But what would be the punishment for that untouchability? What would be the provisions? What is the law? That authority has been given to the parliament, okay, which will enact the law, or state legislative assemblies. Clear? So remember, Article 17 is not self-executory. There are certain articles which are self-executory. By self-executory, it means that Article 17 requires a law to be enforced. Without any law made by parliament or state assemblies, you can't punish any person for untouchability. Okay, so the punishment shall be decided by the law. So this is not self-executory. Now, subsequent Supreme Court judgments have clearly said that untouchability doesn't mean literal untouchability, that someone is refusing to touch anyone, so that is punishment. All forms of caste discrimination are covered under untouchability. Okay, not just touch. All forms of caste discrimination, even if you are using derogatory slurs for these people, okay, disadvantaged people, they too would be categorized as untouchability. So you can't say that untouchability only means with respect to touch. All forms are covered, okay? Social boycotts, forced segregation, manual scavenging, caste-based occupation, everything is covered under untouchability. Now, this is not a self-executory article. So to execute it, laws were enacted. There are three major laws. Protection of Civil Rights Act, okay, 1955, which became SC/ST Act, then Prohibition of Manual Scavenging Act. These are the laws, clear? And certain landmark cases for Article 17. Well, these are those landmark cases. Now, as far as Article 18 is concerned, well, there are no important current affairs with respect to Article 18. Some static portion with respect to Article 18, so that what if UPSC asks any MCQ with respect to Article 18 in this time's prelims? So to cover that, some static information related to Article 18 is given in your notes, so do cover it from there. Okay, cover all the tables, memorize all the tables. It's very important. These judgments are very important. Okay, and read Article 18, which is given in your notes. We won't spend time discussing it in today's lecture. All right. So with that, we conclude the entire topic of right to equality from Article 14 to Article 18. Now, do not forget to memorize it from the notes. If you have any doubts, use the WhatsApp groups. And when the test would come around, you have the date sheet with you. When the test would come around, do give the test diligently. Okay. With that, I'll be signing off. Thank you so much for watching, everyone. And I'm sure it has added value to your preparation. Now, I shall see you around next time with another topic in this lecture series called Prelims Powerplay. Thank you, everyone.